There's been concerns about why the Attorney General must jump the gun to actually go advising the president not to assent the bill, even before the bill gets to the president. And I ask, is it not within the limit of his duties within Article 88?
Sorry, you have to take it. You have to take that again.
So the Attorney General in that letter, Nana Santebedieto, who signed the letter, says the Attorney General has already advised the President not to assent to the bill whilst there are injunctions in the court against the bill. And so he says that he should only assent it after the issues have been dealt with the Supreme Court. And before I even get to the injunction and whether that has any implication on the president's assenting to any bill into law, I want to find out if the Attorney General's attempts to advise the president is not within his remit, as provided by Article 88.
Well, absolutely within his remit. The Attorney General is the chief legal advisor to government. So the Attorney General's job is to advise the government on the constitutional implications of various actions. It's important for us to remember, at least in this context, that the president can't be impeached if it is established that he has acted in a manner that violates the Constitution. So it is utterly imperative for the Attorney General to advise the president on the constitutional implications of key decisions the president wishes to take. Because those may have constitutional ramifications, especially as in this context, there is an issue of a potential court order or an injunctive relief being sought, which is pending in the meantime, that has consequences in law, and people understand this. So in terms of the Attorney General's advice to the president, obviously, that falls within the remit.
That's where I bring in these applications at the Supreme Court. What has it got to do, or what has it not got to do with the president assenting the bill into law?
Again, if I understand the interplay of things, it appears that as we all know, there's an injunction pending in court against the bill. So if I understand the context of the Attorney General's advice, obviously he's advising the president that because there is an injunction pending against the bill, and because in law, the consequence of the pendency of an injunctive relief is that the person against whom the injunctive relief is sought is supposed to refrain from undertaking actions that may have the effect of undermining the outcome of the application when eventually granted. So if I understand the context of his advice, obviously he's asking the president not to go ahead to sign the bill, since one of the reliefs that is sought is that the president should not sign the bill. And so if he does sign and the relief is granted in the end, he may have violated the application for injunction, which is pending against him. Again, I haven't seen the advice.
That's what I want you to clarify for us. What is the procedure? Has it got anything to do with Article 106, that when a case is at the Supreme Court seeking for interlocutory injunction to injunct the president and all of that, the president cannot go ahead to fulfill his mandate as provided by the Constitution?
Article 106 doesn't say anything about injunctions. I dare say that the Constitution doesn't appear to contemplate what is happening. And therefore, I would go ahead to even assert that this appears to be a major design flaw with the Constitution. It seems to expose major cracks in the structural framework of the Constitution. Now, first of all, the Constitution is designed on the principles of parity. So the three organs of government are equal. Nobody's above the other. But the courts have naturally enjoyed the power and authority of determining what the law is. And because the courts are given the authority to freeze things in time whenever there's a contestation over some particular matter before the determination of that matter, an injunction has always been used to freeze those things or those contested matters. Now, clearly we have a situation here in which an injunction is being used as an instrument of stultifying or blocking the performance of a constitutional duty by the president. And as I understand it, the minority has gone to court. The same is happening, in which case you have your parliament being stopped or stultified by way of an injunction from performing its functions. What may be happening here may be a decision before the courts to ask the bigger question on whether or not a constitutional actor can be stopped from performing a constitutional function by way of an injunction. Now, mind you, we've had this in the past. We've had the Electoral Commission, we've had other bodies injuncted from performing their functions. What I haven't come across in this case is the high-level executive, or rather high-level organs, which is the executive and the legislature, and who knows, the judiciary itself moving forward. So it's one that is novel, and I can say that the constitutional framework did not contemplate this, and it seems to expose a major flaw with the Constitution, because what we may have happening moving forward, if a proper position or pathway out of this is not developed, is that whenever we do not want someone performing his function, the functions of his office, we may simply decide to resort to the power of an injunction. And the critical problem being the mere application itself, the mere pendency of the application itself is sufficient to stop that particular agent or agency from functioning or undertaking the particular exercise or enterprise involved until the determination of the application. And so if the application is not determined for 2 weeks or a month, we may have succeeded in stultifying a major constitutional duty which is incumbent on an organ of government. And some people will argue that that is untenable. So it really exposes a fundamental issue that is worth examining.
Interesting.